Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Ron Hill, decided on June 16, 2022. Singhas, J. Defendant Ron Hill was charged with criminal possession of a controlled substance in the 7th degree for allegedly possessing an illegal synthetic cannabinoid. The public health law's controlled substance schedules criminalize possession of some, but not all, synthetic cannabinoids. Because the misdemeanor to which defendant pleaded guilty failed to allege a sufficient factual basis to conclude that the substance defendant possessed was illegal, that count was facially deficient and should be dismissed. In 2018, defendant was charged, in a complaint, with criminal possession of a controlled substance in the 7th degree, see Penal Law Section 220.03, a Class A misdemeanor, and possession, manufacture, distribution, sale or offer of synthetic phenethylamines and synthetic cannabinoids under the State Sanitary Code, a violation. In the factual portion of the accusatory instrument, an officer alleged that he saw a defendant possess one clear Ziploc bag containing a shredded dried plant-like material with a chemical odor. Based upon his training and experience, which includes training in the recognition of controlled substances, and their packaging, the officer averred that the substance is alleged and believed to be synthetic cannabinoid/synthetic marijuana, K2. The complaint made no reference to Public Health Law Section 3306, G, or its schedule which lists 10 prescribed synthetic cannabinoid substances by specific chemical designation. At arraignment, defendant waived prosecution by information, pleaded guilty to criminal possession of a controlled substance in the 7th degree in satisfaction of the accusatory instrument, and was sentenced to a conditional discharge. Defendant appealed, arguing that the misdemeanor complaint was jurisdictionally defective because it failed to allege that he possessed one of the synthetic cannabinoid substances listed in Public Health Law Section 3306, G. The appellate term affirmed the judgment, concluding that the complaint was valid because it provided sufficient notice of the crime charged and an established reasonable cause to believe that defendant committed that crime. A judge of this court granted defendant leave to appeal. We now reverse. A guilty plea generally marks the end of a criminal case, not a gateway to further litigation. People v. Konechny. Certain limited issues survive a guilty plea, however, including jurisdictional matters like the facial sufficiency of an accusatory instrument. The standard for whether a flaw in an accusatory instrument is jurisdictional is whether the instrument failed to give the defendant sufficient notice of the charged crime to satisfy the demands of due process and double jeopardy. People v. Drayden, see People v. Dumais. Pleading errors involving omission of elements of the charged crime are fundamental. They impair a defendant's basic rights to fair notice sufficient to enable preparation of a defense and to prevent double jeopardy. People v. Casey. Because defendant waived his statutory right to be prosecuted by misdemeanor information, the standard governing misdemeanor complaints applies. A misdemeanor complaint is sufficient on its face when the allegations of the factual part, along with any supporting depositions which may accompany it, provide reasonable cause to believe that the defendant committed the offense charged in the accusatory part of such instrument. CPL 100.40, 4, B, C. Dumais, Drayden. To meet the jurisdictional standard for facial sufficiency, a misdemeanor complaint need only set forth facts that establish reasonable cause to believe that the defendant committed the charged offense. People v. Smalls, quoting Dumais. Standing alone, a conclusory statement that a substance seized from a defendant was a particular type of controlled substance does not meet the reasonable cause requirement. People v. Kalin, C. Drayden, People v. Dumas. Turning to the crime at issue, a person is guilty of criminal possession of a controlled substance in the 7th degree when they knowingly and unlawfully possess a controlled substance. Penal Law Section 220.03. Penal Law Section 220.005, defines controlled substance as any substance listed in Schedule 1, 2, 3, 4 or 5 of Public Health Law Section 3306. Section 3306, G, makes certain synthetic cannabinoids Schedule I controlled substances, but does not list all known synthetic cannabinoids. Compare Public Health Law Section 3306, G. Although hundreds of synthetic cannabinoids exist, Public Health Law Section 3306, G. only proscribes any material, compound, mixture, or preparation, which contains any quantity of 10 specified synthetic cannabinoid substances. The 10 synthetic cannabinoid substances are listed in the schedule by their specific chemical designations. For each of the 10 specified chemical designations, the statute also lists some trade names or other names, none of which is K2. For instance, Public Health Law Section 3306, G. 1, lists 1-pentyl 1-H-indyl 3,2,2,3,3 tetramethylcyclopropyl, 2, methanol. Some trade or other names, UR 144. The statute enumerates 9 other synthetic cannabinoid substances in a similar fashion. Synthetic cannabinoids, whether listed in Section 3306, G, or not, have become prevalent drugs of abuse that are designed to stimulate the same receptor in the body as marijuana's active ingredient, cannabinoid 9-tetrahydrocannabinol, THC. Synthetic cannabinoids are not marijuana, however. These manufactured drugs, containing varied chemical compounds, present a public health threat. See also People v. Turner. The public health law's statutory framework, which criminalizes only a subset of synthetic cannabinoids, renders it difficult for both the public and law enforcement alike to reasonably conclude whether a synthetic, 3, cannabinoid is a controlled substance without additional facts. Given this particular statutory framework, the misdemeanor count in this accusatory instrument contains a fundamental defect because it does not sufficiently allege that defendant committed a crime. The officer stated in the complaint that, based on his training, he believed that the substance he seized from defendant was synthetic cannabinoid/synthetic marijuana, K2, because it was a shredded dried plant-like material with a chemical odor. These factual allegations gave a non-conclusory description of the substance seized from defendant and were adequate to state the officer's training in identifying controlled substances, see Smalls. Nevertheless, the public health law's scheme, banning only a limited number of synthetic cannabinoids by reference to their specific chemical designation, requires more to sufficiently plead possession of an illegal synthetic cannabinoid. The instrument's factual assertions gave no basis for concluding that the substance defendant possessed was a controlled substance, that is, an illegal synthetic cannabinoid as listed with precision in Public Health Law Section 3306, G, as opposed to one of the many synthetic cannabinoid substances that are not criminalized in the schedule. As noted, Section 3306, G, does not list K2 as a trade or other name for any of the 10 banned synthetic cannabinoid substances. The complaint's remaining non-particularized reference to synthetic cannabinoid/synthetic marijuana simply does not state whether the substance defendant possessed was illegal. Absent a basis explaining the officer's belief that the substance possessed was listed in Section 3306, G, the conduct alleged in the complaint is as consistent with legal conduct as it is with illegal conduct. The accusatory instrument therefore failed to give defendant sufficient notice of the charged crime. Consequently, under a jurisdictional standard for a facially sufficient misdemeanor complaint, the allegations within this instrument's four corners fail to establish reasonable cause to believe that defendant committed the crime of criminal possession of a controlled substance in the 7th degree as charged. Finally, dismissal of the remaining count, a violation, is appropriate here because the people do not oppose such disposition and defendant was sentenced to a conditional discharge, with no sentence to serve, see People v. Hideour, Drayden. Accordingly, the order of the appellate term should be reversed and the accusatory instrument dismissed. Order reversed and accusatory instrument dismissed. Opinion by Judge Singas. Chief Judge De Fiore and Judges Rivera, Garcia, Wilson, Canataro and Troutman concur. Decided June 16, 2022.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.